My name is Andy Pushalik. I'm a partner in the Toronto office. I'm also the national practice group leader for Dentons Canada's employment, labor, immigration, and pensions practice. Today, we've got a great lineup of speakers. Camille Paradis-Loisel is a senior associate in our Montreal office. Claire Brown is an associate in our Toronto group. Christy Wong joins us from Calgary, and then Salim Visram is sitting in Vancouver. So last month, we talked about the new amendments on non-competition and provisions in wage fixing, as well under the Canadian Competition Act. So this webinar is going to be focused on some of those cases that have come out in 2023 or very, very recently near the end of 2022. And we're seeing, we always see interesting developments every year in employment and labor, but this year in particular already, there have been a number of really different cases touching on different issues that we think are going to be important to your workplace, no matter what your industry is. So in terms of our agenda today, Camille's going to kick us off with some interesting human rights and labor arbitration cases that are actually very favorable to employers coming out of the province of Quebec. Claire will then even things up with some not so good cases from Ontario on some wrongful dismissal matters, one involving an interesting idea about when your contract actually becomes too stale to enforce, and then some good news about a mandatory vaccination policy case as that saga continues in our courts. Salim's going to talk to you about a BC case that's got a lot of media attention. It's about time theft, and it's a positive decision for employers, and Salim's going to take you through how you might be able to use that case and those principles when you're looking at a just cause termination. And last but certainly not least, Christy's going to cover off the latest cases about when employers can deduct CERB payments. So you'll remember the Canada Emergency Response Benefit that was rolled out as part of the pandemic response by our government. And there's been a lot of jurisprudence about when you can actually, or if you can actually, deduct those amounts from wrongful dismissal damages. So very, very interesting lineup for sure. And we delve into the recent legal developments for employers based in Quebec. So thanks again, everyone, for joining. Camille, take it away.
Hi, thank you, Andy. Hi, everyone, and thank you for joining us today for this webinar. As Andy mentioned, today I will discuss recent labor and employment case law in Quebec. Actually, the first case law I will be presenting is a decision of the Quebec Court of Appeal concerning the jurisdiction of the civil courts over a dispute alleging defamation against a unionized employee by an employer representative. So you can change the slide, please. So the facts are the following. So a unionized employee, Mr. Laplante, was dismissed for harassment and because of some comments he made in the workplace, which were considered as inappropriate and racist. So the union filed a grievance to contest the termination of the employee. The employee and his spouse concurrently initiated a civil action against the HR manager in this file. They alleged that the HR manager committed a fault when she announced to the rest of the team the reasons why Mr. Laplante has been suspended for investigation and later terminated. Mr. Laplante and his wife criticized the HR manager because they considered that while making those announcements, she made defamatory remarks about Mr. Laplante. So at the outset of the proceedings, the HR manager filed an application for a declinatory exception, asking the Court of Quebec to declare that it had no jurisdiction to hear the dispute, which falls within the exclusive jurisdiction of an arbitrator. More specifically, the HR manager maintained that if she had committed a fault when she announced the suspension and termination of Mr. Laplante to his colleagues, it was as the employer's representative and not in her personal capacity. So the the Court of Quebec judge dismissed the application for a declinatory exception on the basis that even though in this case the alleged defamatory statements had been made during a team meeting by a representative of the employer, they could just as easily have been made outside the employer's wall. So in such case, these statements would engage the intellectual responsibility of the HR manager. Also, the first trial judge concluded that since the application to institute proceedings alleged that some of the comments had been made after the termination, the dispute could not fall under the collective agreement. Next slide, please. So the decision of the Court of Appeal, so the Court of Appeal decided that the first trial judge erred in finding that the dispute fell within the scope of civil liability and not the interpretation, application, or violation of the collective agreement. The Court of Appeal also noted that a dispute based on allegation of defamation may fall under the collective agreement, depending on the context in which the alleged defamatory statements are made. In the case at hand, since the comments were made at a meeting to announce the termination of an employee, while the HR manager was acting on behalf of her employer, there was an obvious connection with the collective agreement. The Court of Appeal also found that the judge erred in stating that the dispute did not arise from the collective agreement because the comments were made after the termination of employment. And the fact that the alleged defamatory statements were made after the letter of termination was sent does not affect the issue of jurisdiction. What is relevant is the fact that these comments were made during a work meeting directly related to the investigation and disciplinary process, which led to the suspension and then, as I mentioned, the termination of Mr. Laplante. Therefore, the Court of Appeal concluded that the comments were formulated within the broader context of dismissal, and any dispute about them fall within the exclusive jurisdiction of the arbitrator. You can change the slide, please. Thank you. So what should you remember from this decision? Basically, is that a dispute based on allegations of defamation may fall under the collective agreement and thus fall under the exclusive jurisdiction of the arbitrator, and the exclusive jurisdiction of the arbitrator extends also to events occurring after the termination of employment if they are related to the employment of the unionized employee. Next slide. Thank you. So the second decision I wanted to discuss today is also a decision rendered by the Quebec Court of Appeal, and is about pre-employment medical questionnaire and potentially discriminatory questions. So in the decision, the court had to assess basically the legality of a pre-employment medical questionnaire, as well as the extent of the candidate's duty of good faith when completing such a questionnaire. So the plaintiff here applied to the Sûreté du Québec, who is responsible for providing local police services here in the province of Quebec. And the plaintiff began the long recruitment process, and the process required for him to obtain a promise of employment with the Sûreté du Québec. However, the plaintiff had been diagnosed with a neurological disorder when he was 7 years old, the Tourette syndrome. However, his symptoms are really limited and really controlled. As part of the recruitment process, the plaintiff is subject to pre-selection tests to enter the police force, and the plaintiff must pass physical and medical tests, and he also needs to complete medical and as I mentioned, pre-employment questionnaire. The plaintiff here passed the entire process, and he finally received a promise of employment from the Sûreté du Québec. However, the employer later learned that the plaintiff did not declare that he had Tourette syndrome in the pre-employment and medical questionnaire. And he also did not mention his medical condition during the medical examination. So for this specific reason, the employer suspended the hiring of the plaintiff in order to conduct a full investigation. You should also know that during the investigation, the plaintiff also admitted that he had not disclosed the fact that he had in the past consulted a psychologist that he described as a life coach. And also, as part of this investigation, the employer's physician concluded that the plaintiff remained fit to perform the police job despite his Tourette syndrome. However, despite this, the employer still decided to cancel the promise to hire the candidate on the ground that the bond of trust had been broken. The plaintiff then filed a complaint with the Human Rights Commission here in Quebec, which will be referred to the Human Rights Tribunal. The Human Rights Tribunal found that certain parts of the pre-employment medical process violated the Charter of Human Rights and Freedom. However, several other information requested was directly related to the qualification required for the job, which is the case specifically for mental health questions. And since the employer's decision was based on the fact that the candidate failed to declare his medical condition and not on the fact that he had Tourette syndrome, the tribunal concluded that the refusal to hire was not illegal. However, the tribunal awarded damages to the plaintiff in compensation for the moral damages that he suffered in answering some discriminatory questions and undergoing certain medical examination that infringed his right to integrity. Please change the slide. And so the Court of Appeal confirmed the decision of the Human Rights Tribunal. The court concluded that, again, despite the fact that a question is illegal and discriminatory, a candidate must answer the question in good faith and disclose their medical condition. The court also found that a candidate cannot argue that a question is illegal to justify his failure to declare a medical condition or potentially relevant information during the hiring process. And in this case, the evidence showed that the plaintiff made false statements and lacked transparency during the hiring process. And that's why the employer was justified to conclude that the bond of trust no longer existed and the promise to hire had to be canceled. Next slide, please. So the three things that you should remember from this decision. First, the fact that some questions in pre-employment medical questionnaire are discriminatory does not completely invalidate them if they are justified. Every candidate have a duty to act in good faith during the hiring process. And the onus is on the employer to demonstrate that the health-related questions it asked during the hiring process is related to information that is required for a purpose rationally connected to the performance of the work in question. Please move to the next slide. So to conclude my part, I would just like to remind the companies who have employees in Quebec that as per the Charter of the French language, employers with employees in Quebec have until June 1st of this year to have their application forms, documents relating to conditions of employment and training documents that existed before June 1st, 2022, translated into French if they were not already available in French, of course. So I will now hand over to my colleague, Claire Brown, who will discuss the recent developments in Canadian employment law in Ontario.
Great, thanks so much, Camille. So changing gears slightly and turning to some recent case law developments in Ontario, I'm going to speak about two cases. One is a bit of a bad news reminder case, and the other one, as Andy mentioned, is a bit more of a good news, things that we can consider moving forward case. So turning to the first decision, Celestini and Shoplogix, Inc., in this case, the Court of Appeal considered whether the changed substratum doctrine, which we'll get into in a moment, was applied in this particular circumstance. So in this case, the respondent employee was one of the co-founders of Shoplogix. And in 2005, after serving as CEO for a limited period of time, the respondent employee was given the position of Chief Technology Officer with the corporation and entered into a written employment agreement with respect to his employment with the company. Under that written employment agreement, the terms indicated that this employee would be employed as the Chief Technology Officer and would carry out the duties of that office as set by the bylaws and as specified by the CEO of the corporation. The written employment agreement also included a termination provision that provided that Shoplogix could dismiss this employee on a without cause basis by providing him with 1 month of written notice and continuing pay of his base salary and group health coverage for 12 months following his date of termination. In addition, the employee would also be entitled to be paid an amount equal to a bonus that was prorated over the period of the year up until the date of his termination, based on the bonus that he would have received in the year previous. As the Chief Technology Officer, the respondent employee's role focused primarily on transferring product and corporate knowledge within the company. And his role at that time did not involve any sort of sales, travel, infrastructure responsibilities, or financing. However, in 2008, Shoplogix and the respondent employee entered into an incentive compensation agreement, which set out a particular bonus plan for management level employees that varied the bonus that he was entitled to under his 2005 employment agreement. In that incentive compensation agreement, Shoplogix did not mention or ratify the employee's 2005 employment agreement in the terms of the incentive compensation agreement that was agreed to. In addition, the respondent employee experienced substantial and fundamental changes to his workload and responsibilities in 2008. These changes included adding management of important sales aspects and marketing to his portfolio, as well as directing and managing senior staff that were reassigned to report directly to him. It also involved an increase in responsibility by adding travel to pursue international sales and the handling of company infrastructure-related responsibilities, as well as soliciting investment funds. So we flash forward to 2017, and on March 2nd, 2017, this employee was terminated on a without cause basis. At the time of termination, Shoplogix provided the employee with the limited entitlements that were set out under his 2005 employment agreement. And in response to his termination, this employee brought an action for wrongful dismissal, alleging that the terms and conditions of his 2005 employment agreement no longer applied to his employment relationship, given the substantial change in the terms and conditions of his employment. And we'll flip to the next slide to get into what more of that means in practice. So at a summary judgment motion, as I mentioned, the motion judge considered whether the employee's 2005 employment agreement continued to apply to his employment relationship in 2017. And unfortunately, the motion judge determined that the employee's termination provisions of the 2005 employment agreement had become enforceable by the time that the employee was dismissed in 2017. And as a result, the employee was entitled to common law reasonable notice of his dismissal on the basis of an 18-month notice period. This decision was appealed, and on appeal, the Ontario Court of Appeal upheld the motion judge's determination that the employee was no longer limited by his 2005 employment agreement and was entitled to common law reasonable notice of his dismissal. The Court of Appeal highlighted that the changed substratum doctrine operates by placing a limit on when an employee's common law reasonable notice entitlements will be restricted by the terms and conditions of a historical written contract. This principle, in essence, is based on the premise that an employer and employee relationship may evolve in a fundamental way after the written contract was made, and accordingly creates the potential for unfairness or inappropriateness when that contract is applied to the relationship at a later period of time. The ultimate question comes down to whether the employee's level of responsibility and corresponding status escalated so significantly to trigger the application of the doctrine, and that assessment depends on the substance of the relationship as opposed to the form. So in other words, simply providing an employee with a new title is a factor that may be considered. However, the crux of the determination is whether there were actual increases in substance of a fundamental nature to the duties and degree of responsibility of the employee. And if there are increases of a fundamental nature, then in essence, the employee, for all intents and purposes under the doctrine, was promoted, and note the terms and conditions of their employment agreement have changed. However, the court also noted that a written employment agreement can oust the application of this doctrine if the agreement expressly provides that its provisions, including the termination provisions, continue to apply even if the employee's position, responsibilities, salary, or benefits change. In addition, the court noted that a written employment agreement may also continue to have force and effect, even where there is a substantial change in the employee's duties and responsibilities, if the parties ratified its continued applicability when those changes in duties and responsibilities occurred. So the takeaway with this case is a reminder that in circumstances where an employee's duties and responsibilities change, in particular that in circumstances where that employee is provided with increased duties and responsibilities or expanded duties and responsibilities, that employers make sure that they're reviewing their employment agreements and contracts that are in place to ensure that the contract speaks to these circumstances and indicates that it will continue to apply where those terms are expanded. And with that, I'll move on to the next case on the next slide. Thank you. So turning gears entirely and turning back to the life and times of our COVID world, in Croke and VuPoint Systems Limited, the plaintiff alleged that he was wrongfully dismissed following the company's implementation of a mandatory vaccination policy. In this case, the plaintiff was employed as a systems technician by the defendant VuPoint. VuPoint provided satellite and television and smart home installation services, primarily on behalf of Bell Canada. In fact, the case notes that more than 99% of VuPoint's annual income derived from its various relationships with Bell. On September 8th, 2021, Bell informed VuPoint that its installers would be required to receive two doses of an approved COVID-19 vaccine. And as a result, VuPoint adopted a mandatory vaccination policy that required all installers to be vaccinated against COVID-19 and to provide proof of vaccination to the company. On September 28th, 2021, the plaintiff was terminated with notice effective October 12th, 2021. Next slide, please. And while assessing whether the employment contract was frustrated in this case, the court considered whether the reasons for implementing the mandatory vaccination policy. And the court determined that Bell Canada's mandatory vaccination policy was an unforeseen circumstance that was not contemplated by either party at the time that the defendant, the company, and the employee entered into the employment relationship. In other words, VuPoint implemented their mandatory vaccination policy in response to their contractual obligations to Bell with respect to the supplying arrangement that was in place. And accordingly, that mandatory vaccination policy was not contemplated at the time that the employer entered the employment relationship with the employee who was terminated. The court also noted that the company was not required to modify its employment contract with the plaintiff to ensure that he could continue working. In other words, the company was not required to make changes to find a way to provide this employee with work if he was going to refuse to comply with the mandatory vaccination policy on the basis that he provided for refusing to comply with the policy. The courts emphasized that the concept of frustration can also apply to circumstances where the contract may be capable of being performed, but it would be totally different from what was intended when it was performed after the change occurred. So in this case, the court highlighted that the plaintiff was employed as a systems technician, and he would have been unable to perform his employment duties if he, as the job was contemplated and as he entered that relationship as to what a systems technician was supposed to do, as the terms of his conditions requiring mandatory vaccination were radically differed from when the time that the parties entered that employment relationship. And accordingly, the court concluded that VuPoint's vaccination policy was a supervening event that was beyond the parties' control, and as mentioned, was not contemplated by the parties when they entered the employment agreement. And for those reasons, the court determined that it would uphold that the contract was frustrated and was as the reason for in support of the termination. And with that, I will turn the floor over to Celine.
All right, thanks, Claire. So I'm going to discuss two decisions that address time theft as cause for dismissal. And I'll also touch briefly on privacy considerations that might be unique to BC in respect of employee monitoring. So with that, I'll go to my first slide. So this is the decision that was released earlier this year. It did receive quite a fair amount of attention in the local news. But before I get into a discussion of the decision, I do want to note that this is a decision from the Civil Resolution Tribunal. And so the CRT here in BC, for those who are unaware, is a quasi-judicial tribunal, which has jurisdiction of up to $5,000 in respect of civil disputes. But as a quasi-judicial tribunal, decisions from the CRT are not binding authorities. And so to the extent that we wish to rely on this in future decisions, it's not something that that can be relied upon. So in respect of this decision, the employee here was employed for 6 months from October of 2021 until March of 2022. In February of 2022, she was placed on a performance improvement plan. And in the course of the performance improvement plan, a monitoring software called TimeCamp was installed on her computer. In March of 2022, when the TimeCamp software was compared as against her actual entered timesheets, a discrepancy of 50.67 hours was noted, and she was subsequently dismissed for cause. She was given the opportunity in the course of the investigation to explain, And she did indicate that she was working on hard copy documents and also that she did not fully understand how TimeCamp was working. But ultimately, the tribunal was satisfied that she had engaged in time theft. And so after she was dismissed for cause, she subsequently claimed wrongful dismissal. She sought damages before the CRT in the amount of $5,000, and the employer counterclaimed for the amount of $2,600, which included overpaid professional dues, as well as $1,500 for time theft. And so what makes this decision notable is, again, that the employer was awarded damages in respect of time theft. We've certainly seen a number of decisions where there is a cause for dismissal in as far as dishonesty is concerned, theft, fraud, and of course time theft. But in respect of an employee being ordered to pay damages, that's certainly something that is rare. So in respect of cause for dismissal, any allegation of cause is going to start with the test in McKinley v. BC Tel. And so that test can be summarized as considering the matter in context, just cause exists where the employee has engaged in misconduct that is incompatible with the fundamental terms of the employment relationship. And so both in the union and non-union contexts, theft, dishonesty, time theft have each been repeatedly recognized as among the more serious forms of misconduct. But it is still only where that dishonesty is of such a degree that it is irreconcilable with sustaining the employment relationship that just cause may be found to exist. And so in respect of time theft specifically, I looked for both decisions in the union and non-union context. It was a little more common to be discussed in the union context. And so I want to discuss this Enbridge v. Unifor case. It's also a 2023 decision from Ontario. And in this decision, a long service griever, he was employed for 23 years, including 14 years as a permanent employee. He had a relatively insignificant prior disciplinary record, and he was dismissed for cause, again, the cause being time theft. So over the course of an investigation that occurred over approximately 5 months, the GPS tracking software in his truck was considered, and it was found that he had spent approximately 200 hours, again, over the course of 5 months, being paid for his services when his truck was not physically located at the work site where he was supposed to be. But during the course of the investigation and also at arbitration, the griever maintained that he had done nothing wrong, that his argument was essentially that in many cases, as he worked in tandem with another employee, in many cases, it was only one individual that was required to perform the services. And so to the extent that he would not have been required in any event, it made no difference in his opinion as to whether he was located at the site or if he was at home. He also did bring up some concerns in respect of the COVID pandemic, as he did have some particular vulnerabilities in respect of his family. But ultimately, the grievance was dismissed. In dismissing the grievance, however, the context was thoroughly assessed by the arbitrator. The arbitrator considered the griever's position as a floater, so that he did not, his position was such that he did not require direct supervision. He had significant autonomy as to how he performed his services. He had also been trained recently in the company's business conduct policy. And so that included a responsibility to act with integrity. The arbitrator was satisfied that his misconduct was deliberate, was willful, again, that he had shown no remorse at any time, both during the arbitration and during the investigation. And the conduct had occurred over the course of 5 months. And so the key takeaway from this decision was that I believe this is kind of more indicative of the type of facts and the type of analysis that would support a just cause dismissal where the allegations are related to time theft. So just quickly to touch on employee surveillance, BC does have specific privacy legislation that applies to private organizations. It's called the Personal Information Protection Act, and it does regulate the collection, use, and disclosure of employee personal information. There are also a number of guidance documents from the BC Office of the Information and Privacy Commissioner in respect of employee surveillance. And so there's certainly a number of things that need to be considered in respect of implementing any monitoring software. In respect of implementing employee monitoring, I believe best practices would be to obtain the employee's consent, to have a clear policy in place in respect of what the employer's expectations are of employees during working hours, if monitoring software is going to be implemented, how that software will work, what it tracks, when it is active, if there's going to be investigations or reviews, when those investigations and reviews would be considered, if discrepancies are noted, how the employee will have an opportunity to respond to those discrepancies, and of course, if there are any disciplinary consequences, what those disciplinary consequences are and how they will apply. There's also an exemption in PIPA in respect of investigations specifically. And so to the extent that obtaining the employee's consent may prejudice the investigation, consent may not be required. However, that exemption is fairly narrow. So to the extent that the exemption applies, consent may not be required, but also there are a number of other privacy laws contained in PIPA, including in respect of what information can be collected, how that information is used, how it can be retained, and how it's stored. So certainly those laws will continue to apply. And just quickly, I do want to note that we did do an insight in respect of privacy and employee monitoring just earlier this year, so I will post a link to that after Christy's section. But with that, I will turn it over to Christy.
Thank you, Celine. So today I'll be discussing an Alberta Court of Appeal case that dealt with the issue of the deductibility of CERB payments. Next slide, please. So the case is Oostlander and Cervus Equipment Corporation, and the big question that this case determined is whether or not CERB payments should be deducted from wrongful dismissal damages awards. So a little background before diving into the case. In March 2020, when the world shut down from the COVID-19 pandemic, which is a period I'm sure we'd all like to forget, the Canadian government introduced the Canada Emergency Response Benefit, or CERB. And that was a financial support program meant to assist those whose employment had become affected by COVID-19. So the issue regarding the deductibility of CERB payments began when courts began hearing wrongful dismissal cases where the termination occurred during the peak COVID-19 times. And it became an issue when deciding wrongful dismissal damages. So damages in a wrongful dismissal claim are meant to award the employee for any wages and compensable benefits that they would have earned during their notice period. So in some cases, the terminated employee would have earned CERB payments during their notice period. In Canada, the lower level courts were divided on whether CERB payments should be deducted from wrongful dismissal damages. And if they were to be deducted, then essentially the employer would be able to offset the amount of the CERB payments that the dismissed employee received against the damages that they owed the employee. If they weren't deducted, then the employee essentially would receive a windfall, which was also referred to by the courts as a compensating advantage. So essentially, the term compensating advantage refers to any advantage that flows to the employee and is connected to the employer's breach. So essentially, it has that but-for causal link. But for the employee's dismissal, they would not be receiving CERB payments. So let's dive into the case now. The case was first heard at the Alberta Court of Queen's Bench, where the terminated employee, Mr. Oostlander, alleged that he had been wrongfully dismissed in July of 2020. He was ultimately successful with his claim, and the court awarded him a reasonable notice period of 24 months. During that notice period, from July 2020 up to July 2022, Mr. Oostlander had received some CERB benefit payments. The trial judge held that those CERB payments should be deducted from the employee's damages award. Mr. Oostlander appealed, and this brings us to the Court of Appeals decision. Next slide, please. So the Alberta Court of Appeal ultimately concluded that CERB payments should not be deducted from any damages awards given to wrongfully dismissed employees. And the Alberta Court of Appeal was influenced by the British Columbia Court of Appeal, which had also decided a CERB deductibility case, Yates and Langley Motorsport Centre Limited, just a few months prior. In that British Columbia Court of Appeal case, the court concluded that CERB should not be deducted from wrongful dismissal damages, and they were persuaded by some broader policy considerations that favored non-deductibility. First, there was the desirability of having equal treatment of those in similar situations. Essentially, if CERB income was to be deductible, then it could end up in a situation where an employee who started receiving CERB payments at the very beginning of their notice period would be at somewhat of a greater disadvantage than some employees who receive CERB payments at the very end of their notice period. Second, there was the possibility of providing incentives for socially desirable conduct. So non-deductibility would remove that incentive that for employers to terminate an employee if the employers would think that this would essentially or potentially reduce their liability if their damages were offset with any CERB payments that the employee received. And third, the court wanted clear rules that were easy to apply. Since the purpose of the CERB payments was essentially to deliver quick, simple emergency aid during a time of great uncertainty, the court also wanted some clear rules that could be applied right away without needing to revisit awards and apply deductions later on. Both the BC Court of Appeal and the Alberta Court of Appeal agreed that if a windfall was going to happen, it was best to reflect the intention of Parliament and the windfall go to the employee. After all, the CERB program's goal was to mitigate harm to those who had lost their employment. Lastly, when coming to its decision, the court did not place any emphasis on whether the CERB benefit would eventually need to be repaid, noting that this wasn't a concern for employers, but instead a matter that should be dealt between the employee and the authorities administering the CERB program. Next slide, please. So what does this mean for employers? For starters, only the courts of appeal in Alberta and British Columbia have released decisions on this issue, both courts confirming that CERB payments are not deductible. So as a result, employers in Alberta and British Columbia most likely will not succeed if they're trying to deduct CERB payments from wrongful dismissal damages. For the other provinces, these decisions will likely be persuasive, and we eagerly await some appellate court decisions from the other jurisdictions. Now, this decision largely impacts wrongful dismissal actions where the termination took place as a result of or in the same timeframe as the COVID-19 pandemic. But it's important to note that the termination did not need to be as a result of the pandemic. So while the BC Court of Appeal decision did involve an employee who was laid off with the onset of COVID-19, in the Alberta Court of Appeal decision, the dismissal was not related to the pandemic. So the termination could be for any reason, but the key is that the CERB payments were received by the dismissed employee during their reasonable notice period. And that includes my portion of the presentation, and I'll hand it back over to Andy.
Great. Well, thanks to everyone for being so efficient with their time. And we're going to try and get through a few questions. And Celine, the first question is for you just on the facts of that time theft case. And we have a question about whether or not the decision was clear if the employees knew that the time tracking software had been installed for the purpose of potential discipline.
Sorry, that's in respect of the first decision
Yeah,
there.
that's
And
right. Yeah.
yeah, so that was just installed on the one employee's computer in respect of the performance improvement plan. So there was, prior to that software being installed, there was some concern with respect to her performance and her time not lining up with the amount of work that was being done. And so she was aware that the software had been installed on her computer in respect of her performance.
That's great. And Camille, we have a question just on the implications, and maybe we can talk more broadly about what's the upside downside. So let's think about the situation where you had in this case where the employee will try and start a civil action, and then then what can happen is the judge says, no, actually this should be an arbitration. So what do you see as the upside or downside for when those types of cases happen?
Yeah, well, here, what's important to know is that there was already a grievance that had been filed by the union to contest the termination of the employee. So the argument here was that, everything should be disputed before the same tribunal, hence the arbitration tribunal. And if the arbitrator comes to the conclusion that the termination was not justified and that the employer, through his HR, manager, acted in an abusive manner because of the alleged defamatory comments made by HR, then the arbitrator will have, full jurisdiction to provide moral damages. But the debate here should not be duplicated. And I think the reasoning here is also that it's kind of unfair that a human resources manager who acts within the scope of his or her employment and follows orders from the employer has to defend himself or herself before civil courts.
Great, thanks Camille. Another question about time theft, and we'll maybe open this up. So Salim, good job popping up so quickly. Are we aware of any cases where time theft was found, where there was no admission of the theft, and where no tracking applications were used? So go ahead, Salim. Obviously, there are those cases out there, and I don't know if you want to just kind of provide some basic insight on what to do when you think that you might have an employee who's just not really working very hard. In our experience, I think what you need to kind of consider is don't look at it so much as just time theft, look at it more broadly as dishonesty. And if you are aware of someone who is just not being as productive, yes, it's very helpful in this time of technology to have surveillance, but you may also just have evidence of seeing people who are, and to use an extreme example, napping at work. That would be time theft. That would be people who are not working. But really, it's a broad cases of discipline involving dishonesty, involving just poor performance, and you don't necessarily need to have very fancy or sophisticated tracking or surveillance methods. You just need to have someone who is walking around the plant floor or checking in on employees when they're supposed to be online and they aren't. And then when they aren't, confronting them about that. So we have another question on time theft. This is a very popular, Salim, you're a popular guy today. And this one is a bit more nuanced. Regarding time theft in British Columbia, specifically extending breaks, what would an arbitrator require from an employer as the reason they utilize video surveillance to see if someone was extending breaks, which could result in termination? So, Salim, obviously, there has to be some notification in order for this stuff to stick. What guidance would you give to employers on this point?
Yeah, certainly in respect of notification as to what softwares or what monitoring software is being implemented, as far as the purposes for implementing any sort of monitoring or surveillance. That should also be clearly stated and absolutely reasonable in respect of if it's video surveillance in the workplace with respect to extending break times, certainly where that surveillance is placed, such that is also considering employee privacy as well. But essentially, in respect of implementing any sort of monitoring software or monitoring policies, that they should certainly be reasonable, and the purpose should be clearly connected to determining employee performance.
Great, thanks, Salim. And for those of you who are in Ontario, you'll know that if you have 25 or more employees, you have to have an electronic monitoring policy. So Ontario is a bit of a unique province. Unlike British Columbia, Alberta, and Quebec, we don't have any private sector privacy legislation. In those three provinces, there is private sector privacy legislation that applies to provincially regulated employers. And what Salim's talking about, ticking off the notice and why you're doing it, is all covered there. What we now have in Ontario is not privacy legislation, but an electronic monitoring policy, which requires employers to be very clear as to the type of electronic monitoring that they are using in the workplace. And so if you are using, for example, some sort of keystroke software or some sort of video surveillance, you would need to ensure that you have addressed that in your policy. So when you're considering a case like the example of someone extending breaks and you wanted to show that they're still at the break table by using cameras, you would obviously have to make sure that everyone was aware that those cameras are up and everyone is aware that they will be monitored for reasons of discipline and not just for the security of the premises or for any sort of health and safety type reason. So I think that actually covers off our questions for today. So in terms of next seminar, and wanted to certainly thank everyone again for joining us. So the next webinar for this series, this being our national webinar on employment matters, will be on April 28th. And we're likely going to be focusing on privacy matters and potentially a discussion on artificial intelligence and how that's impacting the workplace with things like ChatGPT and other Autobots as to what that looks like in the workplaces across Canada. The other important point that I want to, or important event that I also want to flag is at the outset, I talked about our Labor Spotlight series. That's on Thursday, April 13th. It'll run from 12 to 1 p.m. Eastern, so 10 to 11 a.m. Mountain and 9 to 10 a.m. Pacific time. And that is going to be focused strictly on replacement workers and when you can use them during a strike across Canada. And for those of you who are following the budget, there was a mention in the Canadian in the budget that the Canada Labor Code will be amended to prohibit the use of replacement workers for federally regulated employers. So an important topic for sure, and something that I hope that you'll all be able to join in the webinar for that one. But for today, we're at the end. So we want to thank you again for your continued participation and your continued attendance. We want to make sure that we're hearing from you. So if there are specific topics that you're interested in, by all means, reach out to the Dentons lawyer that you work the most with and just let them know that you would like it if we address whatever topic is going to be important to your workplace. Otherwise, we hope that everyone has a great weekend and we'll see you next time. Thanks so much.